Okay, so picture this. It's the early 2000s, and Australia is facing a genuine crisis. Insurance costs are just skyrocketing. Beloved community events are getting canceled left and right, and everyone is pointing the finger at a legal system that, well, many people felt had just gone way too far. Today, we're jumping headfirst into the massive legal overhaul that came next, a revolution that completely rewrote the rulebook on who's responsible when things go wrong.
It's a fundamental question, isn't it? Someone slips in a supermarket, there's a car crash, an injury on the job. For literally centuries, judges figured out who is at fault using what's known as the common law. But about 20 years ago, this perfect storm of crazy insurance costs and a few really high-profile court cases convinced governments all across Australia that the system was broken. It didn't just need a tweak, it needed a radical overhaul, and it needed it now.
So, what was the real turning point? The heart of the issue was what everyone started calling a litigation explosion. The argument went something like this. The old rules, the ones that judges had developed over hundreds of years, had just become too generous to the people suing. It made it too easy to bring a lawsuit and win these huge payouts.
Right, so in response to all this pressure, lawmakers decided it was time to step in. They said, we need a whole new rule book, a set of laws specifically designed to rewrite the principles of negligence for the modern world. And get this happened with breathtaking speed. I mean, we're not talking about a slow, gradual change. In just 2 years, between 2002 and 2003, every single state and territory in Australia passed its own version of this new rulebook. This was no small adjustment. This was a coordinated nationwide legal blitz. The official name for these laws? The Civil Liability Acts. Now, these are formal acts of Parliament. And what that means is that they override the common law, that whole body of law built up by judges' decisions over centuries. Essentially, the elected parliaments decided to step in and say, okay, we're changing the rules of the game ourselves. And these acts, they were designed to do two primary jobs. Super important to remember this. First, they were meant to change the actual process of proving that someone was negligent. And second, they were created to put new limits on the amount of money or damages that a person who won their case could actually get. So let's break down each of those.
So, first up, the application of these new rules. Let's talk about proving a case. How did these acts really change what you had to do in a courtroom?
You see, before these acts came along, courts had a lot of flexibility, a lot of wiggle room in deciding if someone had breached their duty of care. The Civil Liability Acts tightened those rules up, big time. For example, they introduced this really important concept called obvious risk. So if you get injured doing something that any reasonable person would know is risky, like, say, diving headfirst into a shallow river, it's now much, much harder to successfully sue someone for negligence. This was a major change from the old common law way of thinking. Okay, now for the second major change. And this one was just as controversial, if not more so. This one was all about the money.
What these acts did was introduce a powerful and, for many, a brand new concept directly into Australian law, a hard limit on compensation. They basically said that even if you prove your case and you win, there might be a ceiling on what you can actually receive.
The acts put a literal cap on certain types of damages, specifically on something called non-economic loss, which is really the legal term for pain and suffering. This meant that no matter how severe an injury was, the law now set a maximum dollar amount that a court could award for that person's suffering. This was a radical shift away from letting a judge or a jury decide what was fair in each individual case.
So after this massive nationwide legal shakeup, let's step back. What's the big picture here? What's the final verdict on what these acts really accomplished? To sum it all up, the Civil Liability Acts were this sweeping nationwide reform that really tilted the scales. They made it tougher for injured people to prove their case, and for the ones who did succeed, they put a cap on the financial compensation they could get for their pain and suffering. It was, and there's no other way to say it, a legal revolution, and it had profound consequences for absolutely everyone.
And all of this leaves us with one final, and I think crucial question. This was a massive shift in how our society deals with risk and responsibility. So when you rewrite the rules this profoundly, making it harder for injured people to get compensated, who truly benefits in the end?